Good day to you and welcome to another Paddocks Club video tutorial. I want to have a quick word about exit levies or the compulsory contributions to a levy stabilisation fund. I thought that this was the type of provision one could only expect to find in a retirement development, but recently on checking a deed of sale for somebody, I found one of these things in a completely ordinary purchase agreement. It's true that the earth being purchased was to be part of a homeowners association, but there was this clause that provided that on sale of the property, 5% of the value had to be paid to the HOA. Now, in this particular case, the purchaser was a young man who was wanting to buy for investment purposes. So clearly, this put him off completely. But let's just have a look at it. The whole process made me think about these things a little bit more and go back to their provision within sectional title schemes. So exit levies are perfectly permissible, but what are they? They're in fact a form of servitude that says when you realize this particular asset, you can't keep all the money. You have to give 5 or 10 or 15 or 25% of your proceeds to some other entity. So it's a detraction from your real rights. Can this sort of thing go into a sectional title rule? I don't think that's where it belongs. In fact, I think it should have to be a condition made by a developer. But if it is made, and there are many sectional title schemes that have such provisions, then it needs to be made properly as a rule. And if you look at it in the context of a sectional title rule, what is it? Well, it's something that is affected by Section 32(4) of the Act, which provides that unless you make a rule to the contrary, all amounts must be collected in a residential scheme, that is, in accordance with the participation quota. And if you make such a rule, those people who are negatively affected by the rule must consent to it. So if you come across a situation in which such a rule has been made after the establishment of the body corporate, have a care about whether or not those who were negatively affected were in fact agreed to it. If it's made by unanimous resolution and everybody in the whole scheme buys into it, I guess that would probably be an agreement by those people. Whether it would be an agreement that fell within the scope of the rules is an open question, and whether it would be collectible from people who weren't owners at the time is yet another question. But if it is made as a conduct rule, or should I say made by special resolution in terms of Section 32(4), have a care to whether or not anyone who's negatively affected agreed to it, because that's one of the requirements of such a rule. And my view, just in general, is that if people who were negatively affected did not agree to it, then it would not be valid. Thank you for joining me in this Paddocks Club video tutorial. If you have any questions on this particular complex subject, please ask them in the discussion forum.